Good afternoon, everyone. Thank you, Dean, and thank you for having me for lunch. It was really good, really good. My mama called goulash mama's specialty. So growing up, as soon as I saw that was getting served, I was quite excited. And yes, I am an elder law attorney with the law offices of Sean Weira. And what we specialize in is in helping families plan for what we consider to be the greatest risk facing retirees. And that risk is long-term care. A medical event happening to somebody and having those unexpected expenses of long-term care coming into your lives. Now, what we do as elder law attorneys is very close to estate planning. So you see, there's a lot of estate planning attorneys out there. But if you were to ask your estate planning attorney if they were an elder law attorney and they were to be honest with you, most of them would tell you no. Because elder law is a specialized area of law that focuses in on how to protect your estate and how to protect your, whether it's the healthy spouse at home, if you have a disabled child, or if you just want to protect your estate in general for your beneficiaries. What we look at is how do we prevent these rising costs of long-term care from wiping out people's estates. So today what I'm going to do for you is, and Dean's passed around a folder, our office does seminars every week. And what we do at these seminars is we teach people about benefits that are available and steps that they can take to access the benefits, even though they may not be eligible at that moment in time. So a classic example is if somebody had a retirement savings of $200,000 and they owned their house and they had a couple cars, if they wanted to access veterans benefits and they went to the VA and asked, do they qualify? What do you think they're going to be told? No, you've got too much money, right? Same thing when it comes to Medicaid. Somebody goes into a skilled nursing facility. All of a sudden, they have to start private paying for the cost of that care. They contact the state, say, we need help. We need to get on Medicaid. But they have that money sitting there. What are they told? Sorry, you've got to spend it down. So what we try to do is help families first avoid that spend down. If you could take your money and protect it versus spending down at the rate of $8,000 or $9,000 a month, which would you prefer to do? Save the money. Make it so it's there and it lasts longer. Traditional estate planning doesn't take this into consideration. And we see that quite often. And how many people in here have done estate planning before? Nobody? Wow, I got a captive audience now.
Well, I think you have to have an estate first.
Well, there you go.
A couple weeks ago, I took my money out of the stock market.
Okay, well that's...
Estate planning, because I watched that program on television. The big computers is governing what
the stock trading.
is going up or down.
Yeah, I've seen that. What I refer to as estate planning more is preparation of a will or a trust. Everyone's got something like that. Power of attorneys are very important documents to have. You want to have a medical and financial power of attorney. So those are the bases of a traditional estate plan. You set up a trust. Usually it's called a revocable living trust. And you put your house in there. You put your accounts in there. What I always tell families is, what was the purpose of doing that? Or I ask them that question. And most of the time I get a response, well, I want to avoid probate. And I say, that's very important. So you're on the right track with avoiding probate. But what good is a plan that avoids probate if all the money that was in your estate has been spent on care? Most families, most individuals don't know because you don't think to ask when a loved one goes into a rehab facility, what's the cost of the care there? You see, Medicare only pays up to 100 days. And that's only if you're improving. So I have a stroke, I rushed off to the hospital, they stabilized me, and then they put me into a rehab place to give me some strength, build it up so I can go back home. Not every individual gets to go back home because they're not able to recover as quickly. Some take longer to get back home. The thing is, after Medicare stops paying, the cost of private pay in a skilled nursing facility right now is about $8,000 a month. There are some places that are higher than that. Few places that are lower than that. That's the going rate right now is about $8,000 a month, or stretch that out over the year, close to $100,000 in medical expenses. That's not covered by your Medicare that's not covered by your secondary insurance, Blue Cross, whatever it may be. Does anybody in here have long-term care insurance? All right, got a few hands raised. That's good. Typically, I'll do a seminar for 20 to 30 people and maybe one person has long-term care insurance. So, you know, I'm not here to talk about long-term care insurance. What I'm going to talk about is what other things can you do to insure against that risk or protect against that risk. And what we do in our office is we set up plans for families to shield their estates. And the best analogy I can create for you is imagine you have, we were talking earlier, there was a $200,000 retirement account in your house. Let's say there's also a cottage up north, something that was built in the family 40, 50 years ago. The family's been using it, still using it. Now, when you go to determine eligibility for benefits, they're going to count the value of that place up north as a part of your estate. They won't count your house. They won't count your car. You can have a prepaid funeral agreement. But everything else that you have, that retirement account, whether it's IRAs, annuities, those are all countable. And that cottage up north is going to be called countable. So what we do is we say, okay, let's look at your estate and what would you like to see happen if you were in that circumstance? And a lot of families tell me, well, I definitely don't want to ever have to sell the cottage to pay for care. They also look and say, well, if I get sick, I don't want to have to spend all my retirement money. What about my wife? Or what about my husband? You know, so in that circumstance, we then wrap a cocoon around certain assets using a special type of trust. There are more types of trust than we can talk about in the short time we have today. But I will say that the term we use is an asset protection trust. And what this trust does is it wraps a barrier around certain assets in your estate. So when you go to qualify for benefits, those assets are no longer on your spreadsheet, or they're no longer declared as your assets. They are owned by this trust. Now, the benefit to doing that is when you go and file for benefits, you no longer have to disclose that cottage up north that you shielded in this trust. Let's say you move some of your money into this trust. You no longer have to disclose that that money is over there because it's outside of your personal profile. I got to warn you, though, there are good plans and bad plans. And what I see with bad plans is people not realizing that when you transfer money, so setting up this trust and doing that protection triggers a penalty when it comes to Medicaid for the next 5 years. Now, some people have done this planning on their own and they just go outright and give money away or sign their children's name onto their bank accounts or sign their children's names onto their property. Now, there's good reasons behind that because they think when I pass, I want it to automatically go to those heirs. The bad things that don't get considered is what if that child has to file for bankruptcy? Now his name is on your asset. What if that child gets sued by a creditor or has a divorce? Now your assets are getting tangled up in those affairs. And beyond those immediate issues, I generally advise against just putting people's names on property. Secondarily, because it's a gift. When you gift assets away, the state of Michigan will not pay for your care, or you can't access Medicaid to help pay for care, depending on how much you've given away. So let's just say somebody with $150,000 or gave away $150,000 so they could qualify for Medicaid. Well, that's going to create a 20-month penalty. Back 20 years ago, maybe that was the way planning was done. You just gave your things away and you qualified. But the state caught on to that and said, no, we're going to institute a look back. And we're going to ask, have you gifted or transferred any assets over the past 5 years? It used to be 3 years. You can tell by going to 5 years, they're trying to make it a little bit more difficult for people to do this planning. And there are other states that have 7 years or even up to 10-year look backs. So we try to get ahead of the game. In our office, we have 2 types of cases. We have the crisis case and we have the pre-planning case. I like working with pre-planners because these are individuals that say, I don't have the immediate need, so there isn't a loved one that has these long-term care expenses yet. But I see the risk and I want to protect against it. I want to try to beat that 5-year clock. So we set up a plan. Depending on the client's desires, we move assets over and start protecting them. After 5 years has gone by, whatever you've put over in that trust is outside of the scope of your accountable estate. Now, the kicker, here's the good thing, when it comes to veterans benefits, there is a benefit available through the VA. It's a non-service connected pension, often referred to as aid in attendance. Now, what the aid in attendance benefit is, a veteran with a spouse can receive up to $2,085 a month to pay for home care, assisted living care, or even that nursing care. A single veteran can receive upwards of $1,700 a month, and a surviving spouse of a veteran, so the veteran's passed away and there's a widow of a veteran, they're eligible for up to $1,130 a month. Now, when I say home care, this is not just to pay for professional companies. You can use these veterans' dollars to pay your family members. You know, and I see this a lot with families I help. Daughter has been helping mom and dad stay in home and has been going over their house 3-4 times a day, checking in on them, doing things for them, taking care of their needs. And they've done this for the past 5 years, and then they find out, wait a minute, Dad was a veteran. We can get some money to help pay for care and give me a little relief in the home. Well, there's nothing I can do about the past 5 years or however long that person's been given care, but looking forward, we can set up a plan, do the asset protection if we're overqualified for assets in the VA, and then file for the person the next month. You see, the VA still does not have a look back. So where I was talking in the skilled nursing facility and Medicaid where they look back over 5 years, the VA is not doing that yet. There was a bill that just failed to pass the Senate where they were trying to implement a 3-year look back. So we're cautioning veterans and spouses of veterans saying, if you have to do planning, you want to do the planning before that look back gets implemented so you can be grandfathered in. After the look back's implemented, we're going to have to beat a 3-year clock on veterans claims like we're beating a 5-year clock on Medicaid claims. Now, I'm throwing a lot of information out here, and I apologize if I'm going fast, but I will be available after this to answer any questions or anything that you may have. The things I want to touch on real quick is what you should be looking for when having somebody help you with this type of work. You wouldn't go to a criminal law attorney to handle a divorce, or go to a business attorney to handle your criminal affairs. Maybe, who knows? What I'm getting at is be cautious of the attorney that's helping you with these types of plans, because there are not a lot of elder law attorneys out there. And the few that are out there are all reputable individuals. But I want you to be wise about what the costs are when doing plans like this. Because there are some attorneys that will charge upwards of $20,000 to do a crisis plan. And the way that they look at the case is, if I'm helping you protect X amount of dollars, then what is an extra portion to me going to be? Well, the way our firm works is we base our fee structure off of the amount of work that we're going to be putting into a case. So just a quick touch on our fee structure so you understand how it works and you can compare it with other firms. First of all, you want to know, are they flat fee or hourly? Our firm is a flat fee. So we don't charge for those meetings, those phone calls, per document that we set up. We base our fee structure off of the amount of work that we're getting ready to put into it and the length of the retainer. And just for the numbers, our fees range from $2,500 to $7,500. And that range goes from a 1-year quick contract to a 5-year advanced platinum contract where we take care of everything over the next 5 years, including stepping in, filing for benefits, and adjusting the plan. Beware the short, quick retainers, because next year you're going to be charged just the same amount to do a refiling, and then the year after that get charged another $1,500 to $2,000 fee for another refiling. By the time you get done, you could sink $15,000 to $20,000 into what you initially thought was only going to cost a few thousand. So I wanted to share that with you about the numbers, because don't get copped into paying an excessive fee. Make sure that the fee that you're being charged is representative of the work that the attorney is going to do for you. The other thing that I'll tell you is just some brief qualifications for the VA benefit. And in your folders, on the right-hand side, there's a trifold. That trifold says, are you a veteran or a spouse of a veteran? In order to be eligible for this VA benefit, the veteran had to have been honorably discharged, or really discharged in any way other than dishonorably, they have to have 90 days active duty, and one of those days has to be during a congressionally declared period of war. So World War II veterans and Korean veterans are the ones that we're helping a lot right now. We're starting to see more Vietnam veterans file claims. But if you look Pearl Harbor, or from Pearl Harbor to the end of 1946, if they had one day during that period of time, they are eligible for the benefit. Now, there is a medical component to this benefit, so it's not just to give you an extra $2,000 a month. There has to be a medical need. If you need the aid and attendance of another person, that's the quickest definition. If somebody's helping you with things, whether it's managing bills or medications, transportation, helping take care of things at the house, you're on the track to where you may be eligible medically for the benefit. So we got the service eligibility, the medical eligibility, and then back to the very beginning of my talk, there is a financial component. The VA does not have a flat line number like Medicaid does. Medicaid says you can't have more than $2,000 a house and a car. The VA is a little different, but to give you a number, we try to keep our claimants under $50,000. The technical formula they use is based off of the amount of medical expenses, your income, your assets, and your life expectancy. How old are you? So trying to explain that formula it's confusing for me, so I don't even try to explain it. We just basically say you want to keep those assets below 50 when it comes to filing for the VA benefit. So I guess let me pause for a minute and ask, are there any questions on anything that I've brought up so far? Okay.
Well, I guess the question is, when you put your money, your property into a trust, you still have access to it?
Well, yes. That's, depending on which type of trust we are using. Most of the asset protection trusts we're setting up, they are for the benefit of your heirs. And that is what creates that distinction between you and the trust itself. But as trustee of that trust, you do retain control, decision-making control. So you have a point of authority and control over your assets. What I always tell clients is you do not want to put assets into an asset protection trust that you're going to be accessing like your piggy bank. Because if you do, you're going to undermine the protection that's there. So everything is about balance. You strike a balance with an asset protection plan. Now, with a few moments to talk on this, in a crisis, there are things that can be done. We talked about this 5-year pre-plan, but I also said I do crisis cases. Now, in a crisis case, this is where I get a phone call, usually from a spouse or a child, saying my loved one is in a facility now, and they're trying to charge us $9,000 a month. What do we do? Well, in a crisis case, if you have a spouse, there are steps that can be taken to shield the entire estate for the spouse. Qualify the needy spouse for benefits right away. So the state will tell you you have to split the estate in half, spend down half the money. An elder law attorney is going to tell you, no, you could set up what's called a solely for the benefit of trust. And that's one of the tools that we use. This trust enables you to protect everything that you have in your estate for the benefit of the community spouse or the healthy spouse, while qualifying the individual in the skilled nursing facility for the Medicaid benefits. And here's the benefit of getting on Medicaid is that $9,000 monthly bill drops down to whatever the individual's income is minus $60. So somebody has a Social Security check of $1,200 going to a nursing home, they're told they got to pay $9,000 a month. If they qualify for Medicaid, they now only have to pay $1,140 a month. Same care. They can't change the quality of care you receive because you're receiving these benefits. Although I will tell you it's better to be able to go into a facility, possibly pay a few months, and then go on to Medicaid. Because you'll find when you're calling around to facilities, if you're telling them we're going on Medicaid day one, you're going to get some resistance as far as, well, we have a wait list or we don't have any beds available. So an easy way around that is go in with the plan of paying for a few months of care. Once you're in there, transition to Medicaid. So, I mean, everything I'm talking about today is just about knowing that there are options available. Too many times I have clients call and say, I've been told there's nothing I can do. It's too late. And I have the privilege of telling them that it's not too late. But then I have to qualify that and say, I have to do the plan now with one hand tied behind my back. I don't have as many options as I would if we did a pre-plan. So we try to encourage our families, get ahead of the game, get a plan in place. But if you don't have that luxury, if time is of the essence and we need to do something now, there are still things that can be done. So don't let it's too late ever be the reason that you don't do anything. Worst case scenario was a family that I was helping where they had spent down all the resources. And all of a sudden a gift was determined was made in the last couple of years, so they couldn't qualify for Medicaid because of that. They didn't have any money to pay for care. They ended up going back home and struggling to provide care in the home when, had they had done things right, they would have been able to qualify a lot sooner. You see it too many times, or I see it too many times. Most families I deal with only see it 1 or 2 times. They see it within their immediate family when a loved one has the need. I'm dealing with it in my own family, so I come to the conversation not only as an elder law attorney, but as a family member and a caregiver for my own family. And I have a grandmother that we help, and she is the apple of my eye. I love her dearly. She is the inspiration and the reason behind everything I do. So when I look at a family member, I ask not to be offended if I call you ma or dad, but it's because if I wouldn't do it for my family, I wouldn't do it for you. That's the perspective you need to have from the elder law attorney that's helping you. So, any questions? Any comments? Do we have veterans here with us today? All right, yes we do. Thank you for your service. You know, it's, yeah.
Can't forget the really important part here. We gotta work best this way. Don't go too far away. Got a certificate of appreciation for you.
Thank you,
You
Dean.
gotta do it like this. Yes.
Thank you. Appreciate that.
Place for frame. So, first consultation is free.
Yes,
As
sir.
always, just because I said so. So it's good to sit down with them, take a look at what you've got, and if they've got, how often should something like this be reviewed? If they've already got it in place.
I'm glad you brought that up. We do 2 things. I talked about the seminars we do every week. We do free consultations as well. If you haven't had your estate plan reviewed within, I would say, the past 2 years, and if you have had it reviewed and that attorney didn't tell you about long-term care planning and it's only been a year or less, it's worthwhile to take advantage of the free consult. And what we do at that consultation, we sit down, have a cup of coffee. If you're a veteran, bring in your DD 214. That's your 1-page service summary. And then we don't need to see private information. We ask you just to, on a piece of notebook paper, write down his income, her income, and what the assets are. Are there IRAs, bank accounts, and stuff like that, with just estimated balances. I can take from that information and create for you a blueprint of what a pre-plan would look like, of what a crisis plan would look like, and then I can promise you this, I never put a retainer in front of any client at that meeting. I send them home, tell them to think about it, pray about it. If it's something they're interested in, we do send a follow-up letter with a copy of our retainer for them to review, but it's on the client to contact us and actually move forward. We've got a lot of clientele that we don't chase clients. It's more important for us to get the information to them and let them decide if it's something they want to move forward on or not.
So it'd be good to review what you've got. Bruce?
What does the retainer do?
Well, the retainer will start with a revamp of the entire estate plan. So the first thing we do is we set up using our power of attorney documents, which are very extensive in what they cover. So a financial power of attorney, medical power of attorney. If you have a trust already in place, then we might look at leaving that part of your plan alone and just setting up an asset protection trust. If you don't have a trust in place, then we review all the options.
So the retainer is the permission to go ahead and start.
Yeah, the retainer is when you say, you know what, I want you to help us. And then that 5-year retainer, what we do is we set the plan up. We assist you with the funding of a trust, because that's something that we see quite often. People have a trust, but there's nothing in it. You know, you actually have to deed your house into your trust. You have to go to the bank and tell them, I want this bank account to be titled in my trust. If those steps are never taken, then you're leaving it for your heirs to do after you've passed. So it's always important to have funding assistance. And then also filing for benefits is always included in that. We don't charge anything extra for doing veterans claims. As a matter of fact, no attorney can charge, nobody can charge for just filing the veterans application. So we do that pro bono for all of our veterans and spouses. But it's the planning and the moving of the estate that the retainer really represents and covers.
Now, is the retainer a 5-year, you mentioned 5 years, is that a 5-year?
Yeah, well, the top retainer we have is a 5-year plan. What happens after 5 years is the question I always get asked. And that is, most of the work, if not all the work, has been done. So then it's just as simple as filing a 4-page Medicaid application or filing the veterans application. If it's just the veterans application, there's no additional charges down the road to do that. We do that pro bono. With the Medicaid side of things, sometimes there's some additional steps that need to be taken. It's important to note it's not all or nothing. So we don't tell clients to protect their entire estates. It's all in what you want to protect. So after 5 years, if there's still assets outside of the estate, we might have to do a secondary plan at that point in time, but we won't be charging the full rates like we do up front.
That, and if you don't need it, you're going to be healthy the rest of your life. Get a review of it, as well as take a look at your friends and family that may be in a situation, especially, I wish I'd known about the Veterans Day intended for friends of ours. We thought sure that the wife was going to kill herself taking care of him, just because he was a really large guy, continually wrestling him around, doing the care, getting him dressed, and then something would happen where she has to bathe him again. It's like, made her crazy. So, getting that help in the family is what's important about that. So, take a look at your friends and family, pass on Greg's card, and get them help. Get them the help that they need.
If you want to attend a full seminar where we actually go into more detail, the next one we'll be doing at the Kentwood Library. It's over off of Breton Street between 44th and 52nd. We'll be there on the 29th of April. That's a Tuesday night. We start at 6:30 and it goes till about 7:30, 7:45, depending on how much questions get asked. Typically try to stop a few times like I did today and just make sure that if there's questions arising, we ask them right away. Because once again, just like today, we're packing a lot of information into a short amount of time. So that being said, if questions arise later, you've got my phone number, I think, written on almost every piece of paper in that folder. Feel free to call me if you have a question and you don't want to, maybe you don't want to set up an appointment, but you just, I thought of this circumstance. My phone line's always open to you. I'd be more than happy to take the call and see what I can do to answer the question.
Thank you.
So, thank you, Dean.
Very good. Very
Thank you, everyone. Appreciate being here.
Take over, Drew? Yep. All right.
First,